Hello, my name is Michael O'Kane and I'm the head of the Business Crime Department here at Pieces and Pieces. I'm going to talk to you today about criminal cartel enforcement in the United Kingdom and the history of criminal cartel enforcement, including up-to-date developments and likely changes in the future. And that talk will also encompass an analysis of the current UK leniency regime and also proposed and likely changes to that regime. Now, before looking at the United Kingdom, I think it's necessary to have a little bit of a history lesson and go back to the first criminalisation of cartel conduct, which took place in the United States under the Sherman Act of 1889. Now, although the United States has had cartel enforcement criminalised now for over 120 years, the enforcement of that legislation has been very inconsistent. So for the first half of the 20th century, there was very limited amount of enforcement, but post-war enforcement gradually ratcheted up, and we then saw the first prison sentences being imposed in the 1960s. When we get to the 1980s, in the Carter administration in the early part of the 1980s, the US enforcement authorities decided to introduce a leniency program which was discretionary. In other words, if a company discovered that it had engaged in some kind of cartel conduct or restraint of trade type conduct under the Sherman Act, well, that company could go in to see the antitrust division in the US Department of Justice, and it could make full admissions regarding its role in that anti-competitive conduct. It was then a matter for the US Department of Justice to decide whether or not it was prepared to grant immunity to the company. So it was completely and solely at the discretion of the DOJ as to what they did. And as a consequence, that program was not particularly successful. So they would have possibly one application for immunity every year. This program was reanalyzed in the early part of the 1990s, culminating in 1993 with a revised leniency program both for companies and shortly afterwards for individuals. And what that meant was that if a company discovered it had been engaged in anti-competitive conduct of that nature, the company could go into the US Department of Justice, and if the US Department of Justice was unaware of the particular cartel, the company would get complete immunity from civil fines by the US Department of Justice, and all the company's past and present employees would get a complete pass on criminal prosecution by the US Department of Justice. And that change to that particular program turned out to be potentially one of the most successful policy changes in criminal justice enforcement anywhere in the world, because the number of cases that became self-reported went up by something in the region of 2,500% over the period of the next 12 months. And that sea change in the policy led to a significant enhancement of the capability of the US Department of Justice to effectively combat cartel conduct. So from 1993 until 1999, most of the US cartel enforcement program was aimed at national or domestic cartels, the most famous of which was the lysine cartel, which has been epitomized in a film and a book called The Informant. The success of the DOJ in targeting national cartels was such that by the end of the 1990s they were beginning to turn their attention to international cartels, and in particular individuals who were foreign who had engaged in cartels which had an impact on the US market. The most famous of the early cases was an investigation by the US Department of Justice into a vitamins cartel involving a number of well-known drug companies, many of them based in Switzerland. That cartel resulted in unprecedented fines at the time, including a fine of $500 million against one drug company, Hoffmann-La Roche. Now, it was one thing to get civil enforcement against companies, quite another thing to get the relevant and requisite punishment under the penal system for culpable foreign executives. And this was particularly difficult in circumstances where many countries at that time did not recognize cartel conduct as being criminal conduct. So what the United States Department of Justice decided to do initially was not to seek the imprisonment of foreign defendants, but rather to induce them to come to the United States and plead guilty by offering them a non-custodial alternative in terms of sentencing, primarily imposing a financial penalty. Now, at the beginning of this century, again, US policy began to slightly shift towards a more aggressive enforcement policy against foreign nationals. And that came about largely as a consequence of other countries perceiving that this conduct was essentially criminal in nature and therefore criminalizing it. On top of that, the US Department of Justice introduced a policy of flagging up wanted foreign nationals on the Interpol database, which is known as putting out what's called a red notice. So if a foreign defendant were wanted in the United States, there would be an indictment issued following the grand jury proceedings. And after the indictment had issued, a red notice would then be issued by the International Office of the US Department of Justice. Now, that red notice would mean that the individual concerned could not travel out of their native jurisdiction to another jurisdiction without their fact that they were wanted by the US being picked up at the point of entry when they crossed a border. Now, that can often mean detention with a view to extradition. Many of the individuals sought by the US were young or middle-aged international sales executives who simply were unable to do their jobs with red notices imposed against them because of the demands of international travel. As a consequence, a number of them consented to travel to the United States and plead guilty to cartel offense violations and serve what were then very short sentences in prison. Towards the end of the first decade of this century, the sentences that have been imposed against foreign nationals have gradually increased, and now it's not uncommon for a foreign national in a US Department of Justice cartel investigation to receive a sentence in the region of 18 months or 2 years. So that's enough about the United States. What influence or impact did that have insofar as the United Kingdom was concerned? Well, back at the turn of this century, the UK government, the Labour government, and in particular the Labour Chancellor of the Exchequer at the time, Gordon Brown, was particularly interested in ways to make the British economy more efficient and more competitive. And one way of considering enhancing competition between companies was to create the cartel offence, to make it very clear to business that not only would this conduct not be condoned, it would actually meet the full force of the criminal law. And Gordon Brown famously went on record to describe cartel conduct as nothing more than a sophisticated form of theft. So a consultation was begun, and that resulted in a white paper, which resulted in a bill, the Enterprise Bill, which resulted in the Enterprise Act coming into force in June 2003. The Enterprise Act was wide-ranging across the competition law spectrum, but insofar as criminalizing cartel conduct was concerned, it created a specific offence, and that offence was targeted at individuals who entered into an agreement with their competitors to engage in certain forms of conduct. Set out in section 188 of the Act, the conduct that is described is the most common type of anti-competitive conduct which is considered to be hardcore cartel activity. In other words, price fixing, bid rigging, sharing production or supply are the main types of activity that the legislation was aimed at. But crucially, in the United Kingdom, unlike in any other jurisdiction which had criminalised cartel conduct, the UK introduced a mental element into the offence of dishonesty. Now, there was a lot of debate in the run-up to the implementation of the Enterprise Act as to whether or not dishonesty was appropriate for this type of conduct. Normally, in UK criminal law, dishonesty is reserved for fraud-type offences such as theft, where it is very clear that the conduct that the person has engaged in is of a dishonest nature, and normally there will be a direct connection between the conduct concerned and the loss to a victim and the gain to a defendant. The most famous case relating to dishonesty, which is the leading case from which the definition of dishonesty comes, was a House of Lords case called Ghosh. And in that case, the House of Lords laid down a two-stage test for a jury to consider whether or not the person had behaved dishonestly. The first part of that test was an objective test, which is members of the jury, would a reasonable person consider the conduct alleged against the defendant by the prosecution to be dishonest? And applying that test, did the defendant then, according to that test, believe that his conduct was dishonest, or if you consider that his conduct was dishonest? That test then came to be applied to the cartel offence, and the justification, overwhelming justification for it, was that it was considered necessary to separate what was considered to be less egregious anti-competitive practices from the really hardcore criminal conduct right at the end of the spectrum. The sort of conduct where sales executives would get together periodically, they would falsify the minutes of their meetings, falsify perhaps the expense receipts that they submitted to their companies in order to hide the tracks of what they were doing, that there was a clear commercial imperative, and that customers were ripped off as a consequence. So people clearly paid more than they otherwise would have done. The offence came onto the statute book in June 2003, and the agency that was given primacy in terms of investigating and prosecuting anti-competitive conduct was the UK's Office of Fair Trading. Now, the OFT is a body that has a number of roles, and the bringing of criminal prosecutions and criminal investigations was not a core part of its function. And although this was a concern flagged up at the time during the consultation period, the government adopted a policy whereby the OFT would take the lead in cartel investigations, with the option of being supported by the Serious Fraud Office if the case was of a particular seriousness and complexity. So, what happened? The statute's been on the statute book now for a decade, and to what extent has it been enforced? Well, there has only been one case which has resulted in criminal convictions in the United Kingdom, and that case came about from a cartel in the marine hose industry. Now, cutting a long story short, a number of individuals were arrested by the US Department of Justice in the summer of 2007 relating to a conspiracy to fix prices and rig bids in the marine hose industry. There were only a limited number of manufacturers and suppliers in that industry, and it was alleged by the US Department of Justice that the companies had got together and agreed to fix prices at particular levels, particular periods of time, and also in relation to specific contracts to agree who would be bidding for those contracts and who would win the contracts in question. As a consequence of a deal that was negotiated by this law firm with the US Department of Justice, with some input from the OFT, the two of the UK individuals and one other were sentenced in the United States in a Houston federal criminal court to a term of imprisonment on condition that they would then be taken from the court and flown back to the United Kingdom, plead guilty in the UK, and then if the sentence in the UK was the same or more than that in the US plea agreement, they'd never have to go back to the United States. And that was a very well publicized deal called the Marine Hose deal, which allowed the defendants to serve a significantly shorter period of time in the UK, given the more generous UK parole rules in comparison with the United States, much closer to their friends and their loved ones than they otherwise would have been. Now, some commentators would suggest that that was a case that was handed to the OFT on a plate, and to a certain extent that's true, insofar as the OFT didn't have to engage itself in the arrest and the prosecution of those individuals. By the time they'd come to the United Kingdom, the OFT was very well aware of what was going to happen, and the process was significantly expedited. Although it was an interesting case, it doesn't give a particularly clear reflection as to the enforcement capability or record of the OFT. A much clearer example followed, and that related to an alleged cartel in the airline industry, and specifically in the industry relating to passenger travel. And it was a prosecution that was brought by the OFT, commencing in 2006, against 4 British Airways former and current executives. And the allegation was that they had colluded with, directly or indirectly, their counterparts at Virgin Atlantic with a view to raising the passenger fuel surcharge element of long-haul ticket prices. Now, the OFT's investigation of that case took the best part of 2.5 years. The 4 individuals were charged in 2008, and the case came to trial in April-May 2010. The 4 defendants were acquitted without any evidence being called, and the case posed a number of questions about not only the OFT's practices, but also the operation of the UK leniency regime. So let me say a few words about that. I've mentioned at the beginning of this talk that in the United States, if a company goes in and the US Department of Justice knew nothing about the cartel, the company would get a complete pass. In the UK, the situation is almost identical. So the UK has looked at what the United States has done and sought to replicate it. And now, under the current guidance, we have 3 types of leniency: Type A, Type B, and Type C. Type A is as I have described, in other words, where a company goes in, or an individual for that matter, and describes to the OFT a cartel of which they are unaware. The company or individual gets complete pass from civil fines by the OFT, and it also gets complete immunity on a criminal side from all past and present personnel of the company. Type B immunity is a little more nuanced, where the OFT may be aware of the conduct, but hasn't probably exercised its full enforcement capability. And in those circumstances, immunity is not a given. It's a matter of OFT discretion, both on behalf of the company and on behalf of the individual. And really, in those circumstances, the OFT is looking for what substantial value can be added to the investigation by the immunity applicant, company, or individual. And the third type, Type C, is the type where, as you might imagine, the OFT is in possession of sufficient evidence to bring a criminal prosecution and to use its enforcement capabilities, but an individual or a company still wants to provide additional information to the OFT for the purposes of reducing its fine, or an individual might want to argue they should be immunized because of the substantial added value they are giving to the OFT, and other arguments can be deployed also regarding the role that they've occupied, the minimum position that they've taken insofar as the cartel conduct is concerned, etc., etc. That is ultimately a matter of discretion for the OFT applying the Code for Crown Prosecutors and, in principle, the public interest criteria in the Code for Crown Prosecutors. And to my knowledge, no individual in the UK has ever been granted Type C immunity. Now, in order to get Type A immunity, not only must a company provide the OFT with full details, the company has to fully cooperate. And that cooperation is onerous. And it includes, at the current time, a requirement that the OFT will want the company to provide privileged material if counsel advises the OFT that it is important that they receive that privileged material because it's necessary for the case to proceed. In other words, without it, the defendants would be deprived of the opportunity to have a fair trial. In the British Airways Virgin case, the issue regarding disclosure and regarding the extent to which an immunity applicant must provide privileged material became a key battleground. And it was as a consequence of a series of factors, not least of which were disclosure problems in the process of the application for immunity and discharge of their obligations by the OFT, that ultimately led to the case collapsing. Now, following the collapse of the BA Virgin case, the OFT, to its credit, has taken a long, hard look at its internal operations, its internal structures, and its leniency guidance. And it has issued 2 supplementary consultation papers in relation to that leniency guidance. In essence, the substantive changes that are proposed are that the OFT is going to be much more proactive, rather than, as it has done in the past, in common with other competition authorities, subcontracted the investigation to whichever law firm is acting for the immunity applicant. Recognizing the potential prejudices and difficulties that are inherent in that approach, the OFT is now going to be much more proactive, much earlier in the investigative stage. So in respect of interviewing witnesses, key individuals who are admitting their role in the cartel conduct, and in respect of obtaining electronic material for the purposes of conducting the investigation, the OFT will no longer be leaving that to the exclusive authority of the immunity applicant, but will rather be taking control itself. That's a key and principal change to the leniency regime. The second key and principal change relates not to the leniency regime itself, but to the criminal cartel offence. And you heard me speak a little moment ago about dishonesty being a key element of that offence. Well, as a consequence of considering potential difficulties in the BA Virgin case, and also other cases that the OFT has not brought because it has been advised that there is insufficient evidence of dishonesty, albeit hardcore cartel conduct has taken place, the government has reviewed the necessity of dishonesty as part of the cartel offence and has determined that it should no longer be a requirement. As a consequence, there is a bill currently going through Parliament and is due to go on the statute book later this year, where the cartel offence will be revised and dishonesty will be removed. What will replace dishonesty at the moment is not finally determined, but it is likely that it will be an intent to enter into an agreement That will be the mental element required. And potential defences will be afforded to defendants, such as defendants not taking any steps to conceal the cartel conduct, or having taken legal advice which said that the conduct that they were embarking upon was not a criminal offence. That is also potentially going to be a defence. In essence, if those involved in the cartel have taken steps to draw it to the attention of those who are buying the products or the services that are being provided, that will be a sufficient defence. So watch this space. Clearly the OFT means business. It has enhanced its enforcement capability. It's trebled its number of lawyers and investigators over the last 12 to 18 months. It's learned from its mistakes in the BA case. It will be likely to be more modest in its approach to cases in the future in terms of its prosecutorial priorities, but there is no doubt that it still is fully determined to exercise all of its resources to ensure that the UK's marketplace remains as competitive as possible. And we will have to watch this space to see to what extent it is going to be successful. Thank you very much.